Down for committee stage next sitting day. Call on Government Order of the Day number 3.
Legislation Bill, committee stage continued.
I declare the House in committee for further consideration of the legislation bill. Mr. Chairman.
Speaker. Members, we need a minister. Members, the House and Committee for further consideration of the legislation bill. When we last considered this bill, we were debating clauses 1 and 2. Dr. David Clark had the call and he has 4 minutes 30 seconds remaining. Call Charles Cheval.
Thank you, Mr. Chairman. It's a delight to be able to rise and make a contribution in what has been an exciting debate to date in the committee stages of the legislation bill. It's great to see Chris Tremaine in the chair for these purposes. I know that with the assistance of the officials, he'll be able to answer all the questions that I and my colleagues have for him today on this significant piece of legislation, in particular in the debate around the title and the commencement. But, sir, seriously for a moment, first of all, I want to just say a few words about Clause 1, the title, because although the provision says simply that this Act is the Legislation Act 2010, well, this is a fantastic example of parliamentary understatement, sir, because this little bill, with its plain little title, hides a number of treasures, and I know that Mr. Bridges is itching to take a call on this very issue because he also knows the jewels that lie beneath this modest little title in this particular bill. You see, sir, although we're going to refer to it as the Legislation Act 2012 when it's eventually enacted, because that's how long the process has taken to wend through the Select Committee and through the House. What I think members do need to understand, and those listening to the broadcast and on television watching and otherwise seeing us here in Parliament today, is that there are a number of exciting things that this legislation bill will do that really aren't given a proper clue by concerning the title. First of all, let's have a look at the bills that the acts that this legislation will replace. Again, with a simple look at the title, there'd be no clue as to the complexity that this legislation starts to simplify. Instead of having a Statutes Drafting and Compilation Act 1920, an Acts and Regulations Publication Act 1989, and a Regulations Disallowance Act 1989, the legislation, those 3 Acts of Parliament are going to be streamlined and brought into substantial effect on a modernised basis by this legislation bill. And, sir, not before time. The modernisation that this legislation bill effects with its modest little title is really quite significant. We have, as we've heard in the committee stages, a bill before us that, despite that modest little title, will revolutionise and modernise the publishing, the reprinting and the revising of legislation in New Zealand. That's a most significant innovation. We have a complete reenactment of the scheme of both the Regulations Disallowance Act and also the Acts and Regulations Publication Act, at least as far as those 2 pieces of legislation relate to this new category of disallowable instruments that will be recognised by our law under that terminology for the first time. We have a reenactment of the important way in which the Regulations Review Committee ensures that scrutiny will occur of delegated legislation, because the procedure that is set out in the Regulations Disallowance Act 1989 will be substantially reenacted by this bill. And I know that the scheme of the disallowance regime is well known to many members of this House, including you, sir, but it will be set out in a modernised form with reference to that concept of disallowable instruments by this plainly titled legislation bill. And also very significantly, and this was a matter that didn't get great attention in the committee stages, the legislation that currently governs the Office of Parliamentary Counsel, the Statutes Drafting and Compilation Act 1920, will be completely modernised by Part 4 of the legislation bill. And for the first time, there will be a proper statutory setting out of the basis on which the Chief Parliamentary Counsel holds office, a definition of the relationship between him and the Executive and this body, sir, because, Mr Chairman, it is a tripartite relationship, as the Acting Chief Parliamentary Counsel acknowledged in 2 Select Committee appearances that I was present for that he made today, one in the Regulations Review Committee and one in the Justice and Electoral Committee. And there are some other important innovations that simply wouldn't occur to the reader of this plainly titled Act. There are some important provisions relating to the staff of the Office of Parliamentary Counsel. They've really had quite an ambiguous status in law in respect of a number of important issues, including the issue of whether or not when they provide their important and valued drafting and interpretation advice to ministers or to members when they're assisting select committees or with private members' bills, whether they actually have a client that they're dealing with, or whether there's some more ambiguous relationship that's on foot here. And of course the importance of this is all about whether or not they have an expectation relating to legal professional privilege around the advice and the representation that they receive, that they provide to these figures, including members of Parliament and ministers. And it is important that we are clear that that is the duty that we are clarifying, sir, as well as another important innovation that the bill, not apparent from its title, provides, and that is to extend the same sort of protections from liability that public servants can enjoy at the moment. That is extended to the Office of Parliamentary Counsel and to the staff working in it. So if they do something in good faith and within the powers that they are given by the legislation, then they are protected from liability. They can't be sued as individuals. And bizarrely, that wasn't a position that has been clear in the law until now. It's something that the Select Committee, the Regulations Review Committee actually, when we looked at this legislation, thought was an anomaly. Why should public servants subject to the State Sector Act have those protections? But the valued staff of the Office of Parliamentary Counsel, on whom we rely so greatly day to day in this office, why shouldn't they have exactly those same protections? And I'm glad to see, sir, that those provisions are brought into effect by this Act. It's good to see also provisions ensuring that they are to be appointed on merit, and that the Chief Parliamentary Counsel is to establish procedures for notifying vacancies and appointments and reviewing appointments. This is good modernising legislation. It's timely. It's the sort of thing that the office deserves and needs, and I'm very, very pleased that under the guise of this modest little title we're doing all those things today, sir. So just a word on commencement. Originally the legislation provided for most of the legislation to come into force on 1 July 2011. Then there was a dual scheme put in place to allow for much of the rest of the Act to be brought into effect by order in council, or were those orders in council not made, 1 July 2013. And that's a proper way to do things, appropriate to legislation such as this that deals with matters such as delegated legislation, and the need to ensure that when there is a legislative scheme that's to be brought into effect by regulations, it's not on the never. There is a drop-dead date, if you like, sir, by which the legislation must come into effect if the executive fails to bring into effect orders in council to enact the legislation, or at least to have it in force. And I see that there's a supplementary order paper number 127, which will change that scheme somewhat, push out the latest date by which the legislation must come into force, but Sir, it's still a specified date, and so it can be brought into force earlier by order in council, but there is that very appropriate enacting formula or commencement formula by which the final date on which all of the important pieces of legislation that comprise this measure must be brought into effect, and that's 1 July 2014. So, Sir, I'm delighted that we are finally progressing this bill. It's good to see all these important provisions coming into force, and Sir, I certainly commend the bill in its entirety, and in particular clauses 1 and 2 to the House.
Call Andrew Little.
Thank you, Mr. Chairman. It's a pleasure to take yet another call on the legislation bill.